Hello and welcome to the Herrington Carmichael Employment Law Update for June 2019. My name's Alistair MacArthur, I'm the head of the employment team at Herrington Carmichael, and as always I've got the 4 latest things in the world of employment law for you. So where do we start? Let's start with the topic of shared parental leave and the issue of whether a man taking shared parental leave should get the same rights as a woman on maternity leave. This is the case of Mr Ali against Capital Customer Management Limited and the second case of Chief Constable of Leicestershire and Hextall. These 2 cases looked at the issue of whether a male individual could pursue claims of direct discrimination, indirect discrimination or equal pay, and it was found that all 3 forms of the case could not be pursued in relation to shared parental leave compared to somebody on maternity leave. What does this mean for employers? It gives employers a free rein to now pay something different for shared parental leave compared to maternity leave. I would say though, just be a little bit careful because you might have a few disgruntled male employees if you're doing something which is disproportionate from one group to another. However, you've got a free rein now. Next, working time regulations and the Deutsche Bank case. We talked about this earlier this year and how the Advocate General had given an opinion in relation to employees' working time being monitored and how employers should monitor their employees' working time to make sure they don't exceed the maximum working time allowances. That decision has now been ratified by the European Court of Justice, so we've got a situation where potentially the UK's working time regulations is out of kilter and different to the Working Time Directive. What we're going to have to wait and see is how the UK actually implements this decision. But what's likely to happen is there's likely to be a situation where employers have to much more closely monitor their employees' working time. Keep a watch on that, particularly if you have flexible workers or people who work at home or work away, so you can't actually really clearly catalogue what they are doing. Next, discrimination arising from a disability and the case of Balder and Church's Housing Association. In this case, we have a situation whereby an employee raised on appeal that they were depressed. They hadn't raised this previously, and out in the appeal stage, the employee brings the issue up and says, I'm depressed and my behaviour for which you dismissed me was because of my disability. The employer in this case didn't properly look at it. They just turned a blind eye and counted on what was in the information known in the dismissal. What the courts did and what they looked at was effectively the employer should have gone to a much greater degree and actually gone back and looked at whether this would have impacted on the behaviour and affected the decision to dismiss. When new information comes to light in appeals, employers must be very careful. You can't just blanketly not look at it. So take some care, take some advice. In this situation, there was the risk of a discrimination arising from claim, and the individual actually got a pretty good argument. Finally, the case of base children's wear, which deals with the issue of the level of award which is appropriate for injury to feelings. Now, for many of you, you'll know that injury to feelings are determined by the good old case of Vento. This is the one which gave you lower, middle and upper bands of awards available for injury to feelings. In this case, we had a one-off incident which gave rise to the injury to feelings, and the Employment Tribunal awarded in the middle band. What was appealed was whether that should actually have been in the lower band. However, what's been determined is that every case must be looked at on its own facts, and in theory, a one-off event can end up in the middle band. Take the issues of discrimination very seriously, look at them very carefully, and don't take a light view simply because it may be a one-off incident. And as always, if you need advice on the severity of any alleged discrimination, please do let us know. We'd always be happy to help. That's it from me this month. I will come back to you in July, and until then, thank you very much.